Good. Welcome to another session of Ask Larry. I want to cover what my schedule will be in the future for this. I had a couple comments that these classes moved pretty rapidly, and they had to get through these form changes. So the new format will be on Tuesdays at 11. I will be doing Ask Larry. General sessions, whatever we discuss. And then on Thursdays, I will be doing Real Estate 101. We're going to start taking different parts of our real estate and just going through it very, very slowly. Next Thursday, I have Doug Inger going to join us for a marketing session, how to market yourself. Then the following Thursday, I will start going through our contract line by line. It's not just for new people. If you really want to understand the contract, we are going to go through the contract till we run out of time, and we'll pick it up the next Thursday. But Tuesdays will be these type of sessions. So with that said, let's get into what I want to cover here today. I've had a few questions during the week. One, if more than one person owns a property, you need to have everybody's signature before you have a listing. Okay? Do not try to put a listing into the system with only one person's signature. Against the law and not a valid listing. Most of the things that I come up with are questions are simply because people don't know the definitions in our contract. So I want to do something a little different before I get into the forms today. I want to ask you to go to paragraph 31 of the sales contract. And if you have the forms that they've been sending you, at the bottom of the page, it'll be page 18. Paragraph 31 is called definitions. So to make sure everyone understands how this contract is written and to make it easier to understand, anytime that there is a word that is capitalized in this sales contract that does not begin a sentence, there is a definition in that contract that both buyer and seller have agreed to. Paragraph 31 is definitions. I just want to take our time, go through these definitions. I think it would answer a lot of the questions people have before they even call me. So date of ratification means the date of delivery of the final acceptance in writing by buyer and seller of all terms of this contract to buyer and seller, not the date of the expiration or removal of any contingencies. So in the state of Virginia, a contract is technically ratified when you have all parties' signatures to the last change. The rest of that definition in Virginia is found under legal requirements on page 17 of the contract that says all contracts for sale of real property must be in writing to be enforceable, statute of frauds. Upon ratification and delivery, you have a legally binding agreement. So legally binding agreement is after delivered. What we did with our sales contract is that a lot of the problems that arose is that all of our addendum forms start after the date of ratification. And if date of ratification was when that last signature was received and you had a agent get the seller to sign that last change, and it was 10 days for a home inspection contingency, but for some reason that listing agent didn't get the contract back over to the buyer and the buyer's agent for 3 days, well, then there were only 7 days left for the buyer to do their home inspection, because ratification definition in our contract was when the last signature was obtained. So until the contract is delivered, the date wouldn't start for the home inspection. Not saying a judge wouldn't rule that there was ratification and it might be legally enforceable against one party, but not the other till it was delivered. I'm not going to get into that argument, but we know when the times start. Now, you'll notice some words capitalized even within this definition. Delivery, okay? Delivery is capitalized. So that means you'd have to go to paragraph 6 of your sales contract, which is, according to what I have here in front of me, on page 10, you'll see delivery, okay? So this paragraph specifies the general delivery requirements under this contract. For delivery, the POA, well, that's a little d. So POA and condo docs aren't controlled by this paragraph. But if you go to the second part of number 6, it talks about the methods and whatever, you can read that. But technically, whenever you have a capital D in delivery, until that document gets to whatever's in paragraph A or B, then the clock hasn't started ticking on our addendums. So to the seller, that one is usually filled out only after the contract is ratified, a lot of the time. So you remember when we looked at that information for preparing a contract that the listing agent can use, that new form, it helps with this. So for our agents, you should never write a contract with any blanks in it. If you're the buyer's agent, you need to find out from the listing agent what goes in paragraph A, because if you look at this 6A, addressed to the seller at property address, and property is capitalized. If 6A is left blank, then technically everything has to be delivered in accordance with paragraph 1 of this contract, which says this property described as, as follows, and properties in quotation marks. So you need 6A filled out. 6B is usually filled out because the buyer's agent is writing the contract. So to understand these definitions, anytime a word is capitalized, this is what buyer and seller have contractually agreed that must happen for the contract to go forward. Not what agents want to do and what agents have always done. I hear that all the time. It's always been this way. Well, I'm going to tell you, as long as I can remember, and I've been around for 43 years, it's never been any other way. We've had these definitions for as long as I can remember, okay? So not the date of expiration or removal of any contingencies back in paragraph 31A. So if a contract is ratified when a buyer and seller ratify the contract and it's delivered to the party that needs to receive it, then we have ratification for our purposes of our contract. But what about a short sale? When is a short sale ratified? Well, I hear quite often when the bank approves it, but that's not true. A short sale is approved when the seller, and that is the owner of the property because a short sale, they still own it, and the buyer come to contract terms. The subject to approval by the bank is nothing but a contingency, just like finance and everything else. So be aware that it's not expiration of any contingencies, and the short sale is nothing but a contingency. Appraisal means a written appraisal, okay? Days, now this is where it gets interesting. Days or days, whether it's capital D or little d, means calendar days unless otherwise specified in this contract, okay? So an example would be, how many days does the agent have to get the check into, the earnest money check into the bank? Well, it's 5 business banking days. So unless it says something different, a day is every day of the week, even holidays. Now, all reference to the time of day, paragraph D, is Eastern time zone. When we talk 9 p.m., we're talking 9 p.m. Eastern time zone of the United States. Okay? Here's another confusing one. E, for the purpose of computing time periods. The first day will be the day following delivery, and the time period will end at 9 p.m. on the day specified. You notice D is capitalized in day. Any capitalized D day starts the day after. So if you send me an addendum today, then it starts the day after because it would be a capital D. But what about condo and POA documents? Okay. Well, if you looked at paragraph 8 of your sales contract on page 11 of my package here, on page 11, paragraph 8, POA Act, okay, you'll see where it says in paragraph 8B, for delivery of the packet or notice of non-availability of the packet, buyer prefers delivery. And you will see in the middle of it, they have 3 days or 7 days, which we'll examine here when we look at our Condo and POA Act, to cancel the contract and where it has to be delivery. So little d means not the term that everybody agreed to in paragraph 31, because you can't override statute by contractual agreement. So under the, like, for example, this POA Act, a day doesn't end at 9 p.m. A day ends at midnight because it's a little d. So you have to understand whether you're talking a capital D or a little d in day as to when a day ends. Okay? Legal expenses means attorney fees, court costs, litigation expenses, and expert witness and court reporter fees. You will find legal expenses mentioned in paragraph 27 and 28 of our contract. If someone has to sue someone because they didn't do so in the contract, it includes all these extra expenses. All right. Notices. Another important one here means a unilateral communication from one party to another. Unilateral. I'm sending you a notice that I'm voiding my contract because of my home inspection. It only requires the signature of the person sending. It's not something that has to be signed by the other party. All notices will be in writing and will be effective as of delivery. Okay? So will be effective as of delivery. Delivery is capitalized. If it has the buyer's, seller's email address in the paragraph 6, then I'm sending that to them as well as to their agent because delivery is capitalized. Okay. You'll notice written acknowledgement of the receipt of the notice is a courtesy, but is not a requirement. Okay. We talked about seller subsidy last week. I'm not going to go back and do that one again. But one other way of setting a definition in this contract, if you go to page 1 of the contract, number 8 in the package, you will notice the first sentence, this sales contract is offered on, date of offer is in quotation marks. Whatever you put in that blank is offered on, say July 2nd, 2020. Not so that is now a written definition in this contract because the words were capitalized with quotation marks. There are only 2 paragraphs in our sales contract controlled by date of offer. One of them is paragraph 10, property maintenance and condition, and one of the property condition dates would be date of offer. That is not when a contract is ratified. Date of offer is that first blank that you fill in. The other is paragraph 24, which states that we are entitled to the commission offered by the seller on the date of offer. That is that first blank. You know, our code of ethics 3-2 says the broker cannot unilaterally change the offer of compensation after the date of offer. So that would be a bilateral agreement between brokers. So that protects us, and we establish, not when you showed it, but when you actually, the date of offer in that blank. So that's how you set definitions and how you read this contract. You have to pay attention to the capital letters and the lowercase letters to really understand what they're saying. And most of the times I get the questions, I say, well, was it a capital D or a little d or whatever? And people say, what are you talking about? Well, that's what we're talking about. Remember who agreed to this, buyer and seller. I don't care what the agents have always done. I hear this all the time. We've never done it that way. And this is what the agents say we have to do. Well, which one do you think the judge is going to rule on? What the agents wanted or what buyer and seller agreed to in their contract and agents weren't a party to? So make sure we're clear on those definitions. Anybody have any questions about how you read this contract and the definitions? Great. And I'll be going over that kind of stuff in the general sessions on the Thursdays when I do it. Everybody is welcome to join in, but we're literally going to go through all the forms, have them recorded so people can go back and refer to them and refresh anytime they want. So the next thing I want to cover today is extension of the review period for condominium resale certificate. And that is page 3 of your handout, or whatever the numbers, they had page 3 on the bottom of the handout there, so the form should say that for you. What happened is that a lot of people said, we can't read all this stuff in 3 days. Okay? So a law was passed that went into effect July 1st, that if by written agreement by buyer and seller, you can extend the time period for the review of the documents up to a maximum of 7 days. Okay. Now there's been a little confusion because people have said you can use this form multiple times. Does that mean we can extend it more than one time for 4 days? No. So let's look at the form. It's an addendum made to a sales contract. Check all that apply, extension for POA or extension for condo, okay? And you will notice, let's just take POA, the parties agree that the buyer's right of cancellation provided by subsection B and D of the statute and this contract shall be extended by. Now you have a number up in the top corner. So you could have a number 1 and they ask for an extension of 1 more day, but then they want an additional. So then you could go back and have a number 2 and ask for 2 more days. Well, that means total of 6. You could have a number 3 and ask for that other day if everybody agrees. But the total extension cannot exceed an additional 4 days to review and void your contract. Any questions about that? And all parties have to agree.
So what should we put in the number on the rightmost corner? You're saying either check whichever box we check?
Up at the very top, you'll see a number sign, hashtag.
Yeah, pound sign. Mm-hmm.
So if you're going to ask for 4 days right up front, so it's a total of 7, you would put a number 1 up there because that's addendum number 1 of this, and you would put to be extended by 4 days, then that'd be the only time you could use it one time. Mm-hmm. But if they ask for 1 day and then needed another day, that number up in the right-hand corner would change. Most people, I think, would probably just ask for the additional 4 days right up front. It would only make sense to me.
Mr. Larry, since you send that, I'm sorry, Mr. Larry, if you send this form, it take effect even though the seller didn't sign it.
No, the seller has to agree.
Has to agree. But if they postpone it and they play around, don't want to sign it, then what the process?
If they won't sign it, then it's still 3 days like the law says.
Right.
Larry, does this, we hold the right to cancel also? That also gets extension by 7 days or 3 days?
So, right. So this extends the right to review and cancel the contract for those documents if everybody agrees to the extension of the days. Now, let me make sure you can't use this form to shorten the 3-day period. Okay.
I have a question.
People say, can we shorten the 3 days? No, you can't shorten the 3 days by statute. You know, they have up to 3 days to review them and void their contract.
So you can void the contract within 7 days then, instead of 3 days.
If everybody signed this and agreed to it. So if you sent this over with your sales contract, the seller agrees and the buyer agrees in writing. Now your time period would be 7 days if you put 4 in there. You could put 2 days, extend it by 2 days. Then there would be 5 days to review and void the contract.
That
But
goes
you
against the
can't
seller
sue-
though.
If the seller says no, then there's a counter back. They did not accept this addendum. Then your buyer would have to make the decision, do I want to go forward with 3 days? Okay.
So this is not a must addendum. This is only if you're requesting extra days. Otherwise,
You're-
the original one.
You are requesting and they have to agree to grant. If not, we have the 3 days that's in the statute. Okay. This is not a right by the buyer. This is a request to the seller and they have to agree. Otherwise, we have 3 days.
Can you do it anytime after the contract has been ratified, and if they agree, we can send it?
You could use it after a ratification of a contract. You could send over an addendum asking for more days, but the seller does not have to agree to it. Okay? So you can use it before ratification. You can use it after if all parties will agree. Okay? Everybody's all right with that? Great. I want you to go to paragraph 8 of the sales contract. It deals with this also, okay? In paragraph 8 of your sales contract, the POA Act, I want to make sure we're on the same page. POA and Condo Act are identical in Virginia. They just call their packages a little different language, okay? You will notice paragraph 8 and 9 have been slashed. I mean, really slashed. They used to be a page and a half for each, okay? So we only have this small part in our contract now, which reduced the contract now down to, I think, 13 pages because they took all this language out. So so let's just look at paragraph 8, Virginia Property Owners Association Act. You know, the seller has to say we are or not located within the development subject to the POA, okay? The act requires the following language, okay? If it's subject, a lot located within the development subject to Virginia POA, you can read that part. If it is, it requires the seller to obtain from the POA an association disclosure packet and provide it to the purchaser. The purchaser may cancel the contract, and this is where they made a change here, within 3 days or up to 7 days if extended by a ratified real estate contract. After receiving the association disclosure packet or being notified the association disclosure packet will not be available. So ratified real estate contract, if you look at the definition of our statute, also includes this addendum, okay? So if it's ratified and it's part of this, then it's extended up to the 7 days, can't exceed 7, okay? If the purchaser has received the association disclosure packet, the purchaser has a right to request an update to the disclosure package in accordance with our law as appropriate. But it does, understand, when you order an update, it does not give you the right to then go back and void your contract. The right to void the contract is based on what you have received 3 to 7 days or a notice that you have not going to receive a package. So this is for informational purposes only if you want an update. And the buyer has to pay for it. They can do it, they can order it by the right of a contract, and it has to be delivered to them. I think it's within 10 days, I think what the statute says. I'd have to review that, okay? The right to receive the association disclosure packet and the right to cancel the contract are waived conclusively if not exercised before settlement. Your purchaser cannot waive in writing the receipt of the documents. It's against our statute. However, if they go to settlement and they never receive the document, now they have waived them 100%. They can't come back against anybody because they did not receive them. Now, this has been added to our contract pursuant to 1808 of the statute. Ratified real estate contract includes any addenda to this contract. So if we already have a contract ratified, you send us addendum over and the seller agrees. Now that is part of this contract and the days could be extended for that additional time. Any questions about that? Okay, and paragraph 9 is the same. Now I want to address paragraph 8B. I know we've done it before, but I don't think we can do it too many times, okay? For delivery of the packet or the notice of non-availability of the packet, buyer prefers delivery at, if electronic, or if hard copy. The buyer has to fill out both. They have to fill out both blanks. The statute allows the seller to decide which way it will be delivered. Our statute says the seller must deliver in one of the following manners: electronic or hard copy. So that is their choice. Fill out both. Now you notice the word buyer prefers delivery. Delivery is not capitalized, so you can't go by what's in paragraph 6 because the statute says the seller has the right to decide. Okay? Good. The next thing that we want to take a look at, this is not a mandatory form. Okay? This is something that I would love to see all Fairfax Realty agents get signed, and that is the understanding, okay, your rights under the POA and Condo Act. This is where they have removed all this language from the sales contract. So I think it would be in our best interest that you go over this with the buyer and have them initial and sign the form and keep in your file. It is not part of the contract, okay? So resale certificate should contain, and there are 19 items that a complete package should contain, okay? And you can read through them as well as I can. But number 2 is a pretty important one to me. A statement of any expenditure of funds approved by the Unit Owners Association or the executive board that requires an assessment in addition to the regular assessment during the current or immediately succeeding fiscal year. So a lot of times people get in and they're blindsided because they didn't know about the board had approved this. And it was not going to take effect to repair the balconies till next year. Everybody's going to be assigned, assessed $1,000. Now they're coming back and say, well, no one told me. Well, it's supposed to be in the resale package. What if it's not? We'll discuss that in a few minutes. What if these 19 items aren't included? Number 3, the statement including the amount of all assessments and other fees or charges currently imposed by the Unit Owners Association, together with any known post-closing fee charged by the common interest community manager. So what are the other costs that are going to be involved here? Paragraph number 5, and I'm not reading each one of them, but number 5, to me, this is one of the biggest ones that your purchaser should be paying attention to. The current reserve study report or a summary of such report and a statement of the status and amount of any reserve or replacement fund and any portion of the fund designated for any specified project by the executive board. They have to review these every 5 years and adjust the funds every 5 years. So if I'm looking at my documents and a study hasn't been done in the last 4 years, well, probably there's going to be an assessment coming up in the future to bring these funds up to current requirements. For instance, 5 years ago, they decided repaving the parking lots would cost X amount of dollars. Now it's coming time to repave, and they found out expenses have so skyrocketed that the reserves aren't high enough. Well, all of a sudden there's going to be, boom, an assessment. So pay attention to number 5 if you're a purchaser. Okay? You also want to know under paragraph 6 their budget. Our condo in Florida, I'm at every meeting, and I ask for an explanation of all this stuff. So they know I'm coming, so they pretty much have the explanations in place for me. I actually 3 years ago said, you can't approve this, and they said, well, I said, your numbers don't add up. I was, I guess, the first person who ever actually brought a calculator and added the numbers up, and they had to call another meeting after they got the numbers right. So also number 7, any pending actions or unpaid judgments, okay, or lawsuits. Okay, you need to know that. Number 8, the insurance. I'm not going to try to explain everything here to you, but the bylaws, rules, and regulations. You can see why this is pretty important for them to take the time, and why it might require more than 3 days to read. My attention span reading anymore wanes after about an hour, so I'd probably be asking for an extension if I'm going to receive a packet that has 1,000 pages in it. Okay. And then 19, a copy of the fully completed form developed by the CICD. There is a cover page that is required by the Common Interest Community Board and by our statute to be attached. And it's a summary of the most important items in this package. Right? So those 19 items should be in a package. The POA disclosure packet. So they cover here the POA versus the condo. So same items. We don't need to read through those again. Paragraph 3 on page 6, buyer's right of cancellation. Okay. Buyer's right of cancellation. Make sure you go over this with them. Okay. Shall be current as of the date specified therein. What does current specified therein, date specified therein, what does that mean? These documents can be 1 or 2 years old. If that's the last documents that the owner, the date on the documents that the owner receives, then that's what they can deliver. Okay. So if the documents are no more than 1 year old, I think, according to statute, they have the right to even use those documents. So the buyer can request an update when they look at that in a financial update. However, it does not extend the buyer's right of cancellation under the Condo Act or POA. It's informational purposes only. Buyer's right of cancellation begins upon seller delivery to buyer of resale certificate, including a resale certificate disclosure packet that is not in conformity with the provisions of the Condo Act. What does that mean, Larry? That means if your buyer only receives 10 of these 19 items, the clock has started ticking. Okay? They then have the 3 days, or if you extended it by written addendum up to 7 days, to void their contract. Okay? You can send over all the addendums you want that we're extending the date to allow for the seller to get us the rest of the documents. It's not valid. The statute is very, very specific. You receive anything, it starts your 3 days, and we can't vary the agreement, by the statute by written agreement. If they don't like what they received, or they want to see the rest, then they have to void their contract or go forward with what they received. Okay. And there's a logical reason for that, in my opinion. And the logical reason is this: a seller can't be held hostage forever trying to get documents that haven't been supplied to them. Okay? So the seller can only deliver what they have received. Okay? The parties may extend the buyer's right of cancellation to the extent permitted by the Condo POA Act by ratifying extension of the review period for the resale certificate or the addendum or other comparable addendum. You don't have to use the one drafted up by NVAR, but you can't exceed the 7 days. Any rights of the buyer to cancel the contract are waived conclusively if not exercised within the right of cancellation period prior to settlement. Failure to receive resale certificate disclosure package shall not excuse any failure to comply with the provisions of the declaration. You have waived the right to go against anybody, and you must go by whatever the rules say if you settle without receiving it. Okay. Now, paragraph B is one that I definitely think you need to make sure you go over with these people. The buyers the package shall be deemed not to be available. Okay. And remember, they have 3 days unless extended to void their contract. Okay. If they've received a document or a notice that it's not available or it's deemed not available. So if a current annual report has not been filed by the Unit Owners Association with either the State Corporation Commission or CICB, then the documents are considered to not be available, and your buyer has 3 days to void their contract. Okay? Seller has made a written request to the association, and it has not provided the certificate packet within 14 days. And that's not business days, that's 14 days, then it's deemed not available. Your buyer now has 3 days to void their contract. Okay? Written notice has been provided by the Unit Owners Association. The packet is not available. You get that notice 3 days. Okay? Any questions about any of that?
I have a question. Most of the time, once we receive the package, the buyers wants us to read and just tell them, what is there in the resale package, and then they put the decision on the, agents. They don't read it really.
Well,
so
you want to take on legal responsibility of pretty much practicing law, explaining these documents to what you read? I don't think I want that responsibility. So I tell them I'll be glad to review and discuss with you what you've read when you ask me questions, but I am not going to be the person to read them and take that responsibility.
Okay.
Okay. A buyer may cancel the, yes.
Yeah, Mr. Larry, this is apply for the HOA or the condo association, doesn't matter. For the right to cancel. Both of them. Okay.
It's both of them. It's exactly the same in Virginia. One's called a resale certificate. The other one's a packet.
Yeah. Okay, sir. Thank you.
Okay.
Thanks.
So if you look at paragraph C, this deals with the cancellation without penalty. So within 3 days or up to 7 days are extended by the ratified real estate contract, which could include an addendum afterwards if everybody agrees in writing. After the date of the contract, if on or before the date the buyer signs the contract, they receive the resale certificate. So, or the notice that there won't be one. So if you list a property and the seller wants to be very progressive, they order the documents and they receive the documents. You have them in hand and you hand them to the buyer, okay? Prior to the contract ratification, then their dates start then. That's why in most new homes projects, when do they receive them? Right up front, okay? Or within 3 days or up to 7 days, if extended by the contract, if they're handed to them, hand delivered, or U.S. Postal Service, etc., after ratification. Now, there used to be a form that you could get signed when you handed them the documents. That is not necessary anymore. They did away with it. the contract doesn't call for it anymore. Only time it calls for a receipt if it's overnight delivery or U.S. Postal Service. Okay? How do you prove it? I don't know. I wish they would still have that form, but I guess you did something in writing acknowledging it. Okay? So within 6 days or up to 10 days of extended by ratified real estate contract after postmark, if its resale certificate is sent by mail. So it's postmarked. So one of the safest ways to cover this, I guess, is if you have their mailing address, is to send it, get something showing the postmark it was sent, and if it's sent to their home and they're on vacation, etc., then it's 6 days and it's over, or the additional 4 days if it was negotiated. Okay. At any time prior to settlement, and 4 is ultimate. Look, I get this one all the time. Do we have to wait for the documents? No. The buyer has the right to void the contract the day after contract, okay? If they haven't received the documents. So number 4, at any time prior to settlement, if buyer has not been notified that the resale certificate disclosure packet will not be available and resale certificate disclosure packet is not delivered to the buyer, they have the right to void the contract. Okay? They haven't been notified in writing that there will not be any documents, or the documents have not been delivered to them electronically or hand or overnight delivery, then they still have the right to void the contract. The seller needs to sign the release, move forward, call it a day. I've had agents say, well, you have to wait till we get the documents. Why would you want to make your seller wait all that time to have their contract voided, to get their contract back on the market? Well, they have to give us a reason, Larry. No, they don't. The statute says it's an absolute right. Okay? And then it goes over the notice of cancellation, how you can do it. And I'm not going to read that paragraph to you, but the last sentence: in the event of a dispute, the sender shall have the burden to demonstrate delivery of the notice of cancellation. Okay? You have to prove that it is been delivered to cancel. And I like this last sentence. We just discussed this a minute ago. Broker can counsel buyer on real estate matters, but if legal advice is desired with respect to the contents of the resale certificate disclosure packet, buyer is advised to seek legal counsel. I can't review these documents for you and tell you. We can discuss it, and we can discuss the real estate matters involved with it, but ultimately, buyer, it's up to you. So this form is only signed by the buyer. It is kept in your file to show that you have actually gone over this information that's been removed from our sales contract. So I think it would be in your best interest, Fairfax Realty's best interest, for you to start including this with your buyers. I think somebody had a question. No question? Okay, so it's already 10 or 12. I'm not going to go over the lease today. I decided I was going to make that a separate session, but I do want to cover just a few things that changed in the lease application and the lease rather than going through the whole document. So the exclusive right to lease form, okay, on page 60. So have 60 at the bottom of the exclusive right to lease agreement. Paragraph 5, okay? This is important that you point out to your landlords, okay? As of the date, the second paragraph, landlord owns more than 4 rental dwellings in the dwelling units in the Commonwealth, okay? More than 4. Or 2, owns individually or through a business entity more than a 10% interest in more than 4 rental dwellings in the Commonwealth. So 5, okay? Even a 10% interest. If you have all these different properties in different corporations or LLCs, and you own more than 10% interest in it, then that counts, okay? If you have 5 or more, or 10% interest in 5 or more, you must consider applications from prospective tenants who qualify for Housing Choice Voucher Program, Section 8, okay? If no, then will they or will they not? So they still have the right, if they don't own more than 5 or 10% interest in more than 5, to say no to Section 8. This has been added under fair housing. This was a compromise that our associations worked out with in the statute. Okay? You know that exclusive right to lease. Now, if you own 1 property, you are going to be bound by Tenant Landlord Act. You can opt out if you own less than 3, but they've removed all differences. So under the lease itself, okay, they've added a few things, and we'll take a look at the lease at another session. The maximum penalty for late fee is 10% of the rent or whatever is remaining if they gave you part of it. There is also now a new acknowledgement of receipt requirement. It's in your lease that the Department of Housing and Community Development Statement of Tenant Rights and Responsibilities puts it in supposed to be in plain English. And they have to acknowledge receipt of that in your lease, or you're going to have a hard time evicting someone until you provide it to them. And it is now a 45-day period from the day of the end of the lease or vacating the property for you to refund the deposit. So we're gonna cover that in a separate session.
I have a question.
Okay.
Back to the need to consider Section 8. What does consider mean?
You
I mean,
bet.
I realize that that's yes or no. So you have 2 applications. One is Section 8, one is not Section 8. So just the fact that you've received it, does that mean that you consider it, but you do not have to accept it, correct?
I don't know. I'm not giving legal advice on that one.
Yeah, I think that's really difficult terminology.
Yeah. Well, and remember, politicians wrote it.
Yeah.
But I will submit that question to the board's attorneys and
Okay.
the legal hotline and see their request. I don't think that means you have to accept them over any other, but I think you're holding yourself out at that point for a fair housing lawsuit.
Yes, I think so too. Yes.
So you know, you better
Okay.
have other reasons other than just the source of income.
Exactly. Okay.
So what they've added to the fair housing is source of income, and this is the way they wrote it up. Okay. The other part of that that's not reflected here, they have to, after you have a lease, they have to be approved by the program within 15 days. On the 16th day, you don't have to take them. So, you know, after they have this lease, they submit it to the Section 8. Section 8 has to give their blessing within 15 days.
Yeah, Section 8 has to approve your property, right?
Yes, and it has to be done within 15 days, the funding and whatever, or the landlord can move on. So,
Yeah.
but if it's the only application, you know, and that's the source of funds, and they qualify if the person owns more than 5 properties. So generally, this is going to be more for apartments and places like that, I think, than individual owners.
Right. We're good to know, though. Thank you.
Yeah.
Yeah. If you check that out, that'd be great. Thanks.
Yeah, I'll submit that one to the board's attorneys through the legal hotline.
Okay.
Larry, one question on this one about fair housing that you have to, if you have four or more properties, which is 5, if the landlord is putting it for rent on its own without the agent, so do they still have to follow that, or only agents have to follow?
If they own 5 or more properties, they're not exempt from fair housing. This is not just real estate agents. This is fair housing law in Virginia, so everybody's bound.
So it doesn't matter whether it's agent putting it for rent or the
Well,
landlord is doing it on.
So our fair housing statute in the state of Virginia says you have to own 4 or more properties. If you're an owner and you own 3, then you probably don't have a problem here. Okay.
Mhm.
And you probably don't have a problem under fair housing unless you are a licensed real estate agent or you list it with a real estate agent. But a FSBO that's not an agent, they still have exemptions protected under fair housing. This one here is 5 or more properties. Fair housing is 4 or more normally. Okay. And those are rental properties, not total owner, properties.
Yeah, but owners can decide whatever they want, or they cannot get
Well,
away with
no,
it.
you can't the owner can't decide what they want if it's a violation of statute.
Mhm.
Okay. But if it's a FSBO and they're not a licensed agent and they don't own more than 5 properties, rental properties, or more than a 10% interest in 5 rental properties in the state of Virginia, then they're okay still under Section 8.
Okay.
Okay. Any other questions? Anything else you want to talk about today?
So yeah, I was going to get this listing. I sent you that text message also, where my client has been asking me to put it for sale, but he came to know that his brother already put it in. It came in MLS also, and there were 2 properties. They both owned together, and my client has never signed it, and the agent listed also. So he was upset on the agent that it's not right because I never gave the permission. And then brother went and, contracted.
He should be contacting the broker that has that listing and say, look, you need to take my property off the market. I never signed a listing.
Yeah, but now the other brother wants me to list it, provided both of them sign it.
You're going to have both parties to sign.
Okay.
Whoever's on title has to sign to be able to sell something, and agent can't sell it without both parties signing the lease.
So I'm not going to be owed. I'm not going to be owing any responsibility towards the other agent who has listed, right? If she comes back to me, not if
they did not have the written agreement of all parties. So
yeah,
have your managing broker. After you get the signature of both parties, have your managing broker contact the other broker and discuss it with them, saying, look, we have an signed agreement by both parties. The one party said that you only have one signature. We're requesting you to remove it from the system.
It's been removed. It's temporary off and withdrawn also, but
temporarily off. You have to understand, temporarily off. The other side still says they have a listing. Okay. Withdrawn, they still have a listing unless it is in the category that says canceled. They still think they have a listing. Okay. So, the brother needs to get the party needs to get that straightened out.
Okay.
And someday we'll go over the differences in unless it's actually canceled listing. A withdrawn listing or temporarily off the market, other brokers still saying, we have a listing, stay away from our people.
It was never signed by my client, the other party.
So there's technically never been a listing.
Listing, yeah.
But that's a broker to broker discussion. After the brother that did not sign calls the other broker and tells him, I want this canceled, we're going with our agent.
Mm-hmm. Okay.
Okay.
Thank you. Yeah.
Any other questions? And folks, what Dave and Johanna and Kevin want is just, contact them when you have, broker questions, and then, if they need, they will get in touch with me. But, the brokers can handle most of that stuff. Okay? Any other questions? Well, good. Then I think what I'm going to cover on Tuesday will be the land contract, and that is a contract used to purchase land, not how to circumvent the rights of a lender. And then on Thursday of next week, I have Doug scheduled to go over marketing, and then we'll go from there. Okay, no other questions? Well, thank you for joining in with me today. I appreciate it, and see you next Tuesday.
Okay, Larry.
Thank you, Larry.
Thank you, guys. Bye.